Hi everybody. Thanks for once again tuning into this unconventional way to present class material. I'm just going to jump right in from where I left off on Wednesday regarding our discussion of discrimination. Just as a quick recap, remember, discrimination in the general sense is just a way of differentiating or distinguishing between people or things. It's not necessarily a bad thing. There's a difference between discrimination and unlawful discrimination, and usually when we think of discrimination, especially in regards to the Supreme Court or the Constitution, we're talking about unlawful discrimination. And over the years, the judiciary has developed a scheme or a system of scrutiny or levels of scrutiny that help them determine if various forms of discrimination are or are not constitutional, and that's where we'll move right now. So these tests, we talked about a couple of them, and we've used them throughout the semester. The first one is rational basis scrutiny. Remember, this asks whether or not the challenged discrimination rationally relates to a legitimate government purpose. So there's two important words there. They're italicized here. Is the challenge discrimination rationally related to a legitimate government purpose, right? So all that means is if there's some system of discrimination, what makes that unlawful is if it's not rationally related to a legitimate government purpose. If it is rationally related to a legitimate government purpose, that is lawful discrimination. One example is that you have to discriminate on age for Social Security benefits. People over, I think they changed it, I don't even actually know, it's like 67 or something like that. Only people over 67 are eligible to receive their Social Security benefits. Right, that age discrimination there is rationally related to a legitimate government purpose. The rationality of it is that, well, we need to have some cutoff, and the legitimate purpose is doling out benefits only to those who sort of need them or deserve them. On matters of rational basis scrutiny, the court is pretty deferential to states. They don't require the states to prove a whole lot. They only need to prove, well, it's rationally connected to some government purpose or something we're interested in. When it comes to something that is deemed to be subject to rational basis scrutiny, the burden of proof rests on the person challenging the law to prove that the discrimination is unconstitutional or unlawful. The court doesn't ask the state to prove that it is lawful. The second type of scrutiny, and we really haven't talked about this at all in this class, is intermediate or heightened scrutiny. This one asks if a law substantially relates to an important government purpose. Right, so here we see these two italicized words again. For rational basis, it's rational and legitimate. For intermediate scrutiny, it's substantial and important. So rationally related is just, oh yeah, there's some connection between the two. Substantially is a little meatier. It's a little more. It has to be more of an obvious connection, more of a meaningful connection. A legitimate government purpose is just something in which it makes sense for the government to engage, right? It's a legitimate thing the government should be doing. That is distinct from an important government purpose. Important is harder to show. It is a little more difficult to show that something's important to the government. For intermediate scrutiny, think of something about gender discrimination. And again, I don't mean the unlawful gender discrimination, but sometimes there's obvious discrimination based on gender. A good example is maternity leave. It makes sense in some instances that a mother should get more time off than a father because there's some need for the mother to be with the child, in terms of feeding and things like that, that it makes a little bit of sense to discriminate based on gender in a lawful sense. To get even more sort of challenging, beyond just substantially and important, instead of being deferential to states like they are in rational basis scrutiny when it comes to intermediate, the court asks states to provide an exceedingly persuasive justification. You know by now how I feel about adjectives when it comes to tests that the Supreme Court uses. So exceedingly, not only is exceedingly not well defined, but neither is persuasive necessarily. Another thing about intermediate scrutiny is that the burden is not really on the state, and the burden is not really on the person challenging the law. It's a shared burden. So this is a little more in the middle, obviously being called intermediate, but the burden is sort of split both ways. Finally, we have strict scrutiny. We've talked a lot about this. Is this law the least restrictive means to achieve a compelling state interest? We've talked a great deal about compelling state interests. We've used the terms least restrictive means in the past, but the court doesn't always use those terms. When it comes to potential racial discrimination, they are talking about least restrictive means. So there's something called a suspect class. That's race, religion, all these different things. So it's very difficult to discriminate based on that suspect classification. Not impossible, but difficult. And the burden is on the state really to show that they're not engaging in unlawful discrimination. The court just assumes they start from a place of this action is probably unconstitutional unless we are convinced otherwise. So anytime something comes to the court where there's a complaint or claim that there's discrimination based on a suspect class, based on religion or race or something like that, the court just assumes it's unconstitutional. So again, the burden of proof is on the government to prove that it's constitutional. Okay. Let's talk about state action. I keep saying state a lot, and so what does that mean? Obviously in reference to legislation, but what does state action mean? That means any agent of the state, be it a state, a city, a town, a university, a department, the Department of Energy or something in a state, they cannot write laws in a discriminatory manner, and here I'm using the term discriminatory to mean unlawful discrimination, nor can they enforce neutrally written laws in a discriminatory manner. So it's not just the letter of the law, it's also how the law is enforced. Some element of state action supporting the discrimination has to be shown before it comes to be a violation of equal protection. What I mean by that is the state has to do something. The 14th Amendment, the Equal Protection or Due Process Clauses, they don't protect against private discrimination. An individual can discriminate based on race. An individual can discriminate based on religion. A business, for the most part, kind of can. We'll talk about why they can't, but the 14th Amendment doesn't prohibit that discrimination. The 14th Amendment only applies to government, so it doesn't protect against discrimination by private individuals. Various civil rights acts do, so that's why you see that, okay, businesses cannot discriminate based on race or something like that. That has nothing to do with the 14th Amendment. That has to do with congressional legislation. Another thing about the 14th Amendment is that it doesn't actually apply to the federal government, which is sort of this weird quirk. In the 50s, the court said that the equal protection component of the Fifth Amendment makes that sort of apply. The long and short of it is equal protection and due process are not interchangeable, but the fact that the Fifth Amendment does apply to the federal government means all of the principles that are protected by the 14th are protected against the federal government through the Fifth. That's just sort of a weird quirk of the 14th Amendment and precedent thereabout. So the 14th Amendment, it really is just a reference to state action. It's not a reference to government action, generally speaking. So some of the early discrimination cases, we know very well that the judiciary has not been great throughout history about upholding the rights of racial and ethnic minorities. In the Dred Scott case, it was ruled that blacks cannot be citizens, so they were not entitled to constitutional provisions. In fact, the 14th Amendment was written as a direct response to this portion of the Dred Scott case. Recall that the 14th Amendment says somebody's a citizen of both the United States and the state where they reside. So it got rid of this sort of citizenship issue. The slaughterhouse cases, which we talked about earlier in the semester, they very narrowly ruled on the Privileges and Immunities Clause of the 14th. They said the language said it applied only to the United States and therefore did not apply to the states. Even though the case dealt with butchers and it didn't deal with minorities, this was really seen as a way to mitigate the expansion of rights to minorities in the 14th Amendment. There are plenty of civil rights cases, civil rights laws that the court struck down. There are several more that they did not strike down, but the civil rights cases refers to a group of civil rights legislation that they struck down, and those laws were trying to prevent discrimination by private institutions. So to extend this inability to discriminate from government to private institutions, and for a lot of them, the court said, well, Congress just doesn't have the ability to do this. They don't have police powers. They can't sort of tell people what to do. So all of that is various ways that they've not gone above and beyond to protect the rights of minorities, but the Equal Protection Clause was still out there, right? So we know there's some element of due process, but the Equal Protection Clause seems to apply a little more directly to racial discrimination. So the court had to eventually rule on the Equal Protection Clause, and they did so in Plessy versus Ferguson, which, if you know the content of this case, does not bode well for the rights of minorities. So in this case, in the late 19th century, Louisiana had a law that required the separation of all races on the railroads. So there was a black car, there was a white car. Both minorities and the railroads opposed the law, so the railroads didn't even want the law. Interestingly, the Louisiana Supreme Court struck down the law, saying they could not have separation of races for interstate travel, which the law did, right? So, for instance, if somebody was boarding a train in New Orleans and they were coming to Jackson, they would have to be separate. The Louisiana Supreme Court said that's unconstitutional. We're not allowed to do that. Louisiana's not allowed to do that. But Louisiana can require separation of races for intrastate travel. So if you're going from New Orleans to Baton Rouge or something like that, the cars could be separated. In 1892, Homer Plessy, who was an eighth black, but at the time considered, fully black, he bought a first-class ticket for an intrastate trip, so only within Louisiana, and he sat in the whites-only section. He refused to move and was arrested. He knew this was going to happen. He lost in trial court, and then he lost in the Louisiana Supreme Court. And how's this for, sort of coincidences? The judge in the trial was the governor who signed the bill, so maybe a little conflict of interest there. So Plessy's argument here is that the statute is directed exclusively at blacks, right? It was sort of discriminating on race, but at the time we're really only talking about blacks and whites. And the Plessy attorneys say this law imposes a badge of servitude. So even though this isn't enslavement, it's basically sort of the mark thereof. The statute also doesn't define races, which means that it's not narrowly tailored. So even though it is on its face directed at blacks, it's not sort of in the letter of the law, and that's problematic because they need to be narrowly tailored laws. And the other problem is that this can be enforced in a discriminatory manner because the train conductor has discretion over who is considered white and who's considered colored. So not only is it not narrowly tailored, it offers a little too much discretion. So this violates the privileges and immunities of U.S. citizenship because it restricts the right to free travel. Well, that might be true for interstate travel. I don't know if that's necessarily true for intrastate travel, but the Plessy team is using that limited ruling from the slaughterhouse cases regarding privileges and immunities to say, well, it doesn't matter if this is only going on within Louisiana. This is a matter of U.S. citizenship. And Louisiana cannot restrict the rights of U.S. citizens. This is sort of an interesting one. They bring in the due process element, and they say a paying passenger is deprived of their liberty and their property without due process. So you buy a train ticket and you get on. That train ticket is your property, and then you have the liberty to be on the train. Well, they get ejected without due process, and because it's a state railroad, that is technically a state action. So they're depriving Plessy of his life and property without due process. So I don't know exactly how the court would have decided on rights there, but they're making a due process claim. And they're also sort of, buckshot approach here, saying there are human rights to be with one's family, and if there are interracial families, it's violating these basic human rights by separating them. Okay, so there's a lot that the Plessy team is saying here. A lot is sort of, here's why this is wrong. The Ferguson side says this is quite simply a regulation of intrastate commerce, and the state has police powers to do this. The separation of passengers based on this characteristic, based on race, is a reasonable regulation, provided that the accommodations are equal. And what they mean by equal is in quality and in convenience and the same price. So if you can get a seat and it gets you to, the train leaves on time and everybody's charged the same price, there's really no issue here, says basically the state of Louisiana. There's no issue. Sure, they're being separated, but everything else is equal. Right? This is where we get separate but equal. Therefore, there's not actually any discrimination based on race, right? Sure, they're separated, but it's not like they're getting different stuff. They're not getting different train rides. And this is not discriminatory because whites have to sit in the whites-only car as well, right? So it's not just that blacks can't sit in the whites-only car, or blacks are kicked off the train if every seat is taken by whites. Individuals of both races have to sit in their assigned cars. So it's applying equally to both races. And as a fact of the matter, the cars are equal in accommodation, whatever that may mean, but they're pretty similar. So it's not like the white cars are just fancy and swanky and there's free booze, and the black cars are not. It imposes no form of servitude because, well, everybody's getting the same thing. It's just, they're just in different cars. So the question confronting the court here is whether this law that orders that segregation on the intrastate travel is a violation of the 14th Amendment's equal protection guarantee. And they hold that it is not. They rule against Plessy in favor of Ferguson. And the reasoning here is that the 14th Amendment very explicitly was drafted to create legal and political equality. It is not meant to create social equality. In fact, it's not even clear that the purpose of government is to provide social equality. The court writes it could not have been intended to abolish distinctions based upon color. So they're saying the 14th Amendment wasn't ratified to blur the lines between the races. That's not what it was intended to do. It was intended to say, hey, everybody's equal in the eyes of the law. Social equality, social equality cannot, they believe, be achieved by legislation. That is not what government is for. It can only happen, they say, as a result of the natural affinities between blacks and whites. So the court's saying, look, we're not going to get into the social equality realm, and neither should the state of Louisiana, and neither should Congress. If one race be inferior to the other socially, the Constitution cannot put them upon the same place. Again, that's not the role of the Constitution, according to the court in 1896. They say something that we've kind of been talking about here with discrimination, but they said laws that segregate, which is a very specific form of discrimination, of course, Laws that segregate are not automatically invalid because they do not necessarily imply the inferiority of either or a particular race. Right? So the saying segregation in schools and bans on misogyny or interracial marriage have long been considered valid exercises of state police powers. So they're saying here, look, states segregate all the time, and it's been deemed a valid exercise of state police powers for a long time, and we're not going to change our mind here. So to be constitutional, a segregation law, or one that discriminates on some characteristic, it only needs to be a reasonable regulation. See, this is sort of the groundwork for the rational basis test, kind of, but they're saying because there was no sort of heightened scrutiny here, it just needs to be a reasonable regulation. And what they mean here by reasonable is it needs to be based on traditions and customs of the people in the state. So provided that the people and the traditions of the state want there to be segregation, segregation shall be legal in those places. So they refuse to strike down railroad segregation in this case. They also disagree that there's a badge of inferiority or a badge of servitude, as Plessy contends. So this isn't sort of a 13th Amendment issue either. They say any inferiority that blacks feel is their own interpretation, not the intent of the law. So this is really the crux of the argument. They say any inferiority is their own interpretation. This is where we get separate but equal. If the cars are the same, if the accommodations are the same, if the ticket price is the same, there's nothing saying that one group is inferior to the other, so says the court. So that mere separation is only inferiority in the minds of people who feel it that way. But it is not legal inferiority. Harlan dissents and he says this violates all personal liberties. He says there should be able to separate streets, courthouses, legislative halls. If segregation is allowed on railroads, then it's allowed everywhere. Well, some states took that to heart. He said if this is true, then we should be able to have a Protestant car and a Catholic car and a Jewish car and a Muslim car. But of course, nobody would agree with that. So he's trying to make the claim like, look, how can you say that there's one classification that you wouldn't allow segregation, but there's a separate classification where you think it's fine? Why can we segregate based on race but not on things like religion? He said whites may be socially superior in reality, but our Constitution is colorblind and should be used to not uphold that sort of what he deems to be violations of the Constitution. So despite slavery not being allowed, laws like this make it impossible for blacks to achieve social equality, the social equality that they're guaranteed, at least by the letter of the law, by the 13th and 14th Amendments. Harlan predicts that Plessy will be as infamous as Dred Scott. He was just like, guys, we screwed this one up, and this is going to be embarrassing for us down the road, and it turns out he was right. So the consequences of Plessy here is this is separate but equal. This is where we get separate but equal. And the court really ushered in that era of segregation that we know so well. This was the forefront of segregation. So Harlan said in his dissent there, we're going to be able to segregate everything now, and how true that was, how right he was. They did not view the segregation, the Supreme Court here did not view the segregation or the separation of the races as a violation of the 14th Amendment. They did not believe that was the inequality, or conversely, the equality that the 14th Amendment was talking about. They say as long as the accommodations were equal, somewhat equal, right? Equal enough. As long as the drinking fountains both spit out water, the separation is okay, according to the court here. But here's the thing, as we well know, as time went on, the equal part of separate but equal was just out and out ignored. You can read many a testimony from the time about driving through certain areas of the southern United States where obviously black restrooms were not taken care of, whereas the white restrooms were, and black eateries were not sort of up to the same standards as white eateries and things like that. So the equal portion of separate but equal was never really taken to heart. Only the separate part of separate but equal was taken to heart. So that was the basis of the fight against Plessy and against separate but equal. Groups like the NAACP Legal Defense Fund, they began saying, hey, look, Supreme Court, by your own precedent, you say separate but equal is okay. What happens if things aren't equal? So that's how they started fighting for equality in the courts. That's the grounds on which they were making their claims. Victories happen slowly, but they did happen. In 1938, the court said that Missouri was not acting equally because at the time Missouri had a practice where they would pay black students to go to an out-of-state integrated law school. They did that rather than create an integrated law school. And the court said, no, that's not enough. That's not equal, right? Because it's not it's potentially not equal if that's what you're doing. So there was some gains somewhere in the early to mid 20th century, but right in the center of the century, there was sort of this early major victory, Sweat versus Painter from 1950. So this is one of the sort of primary examples of the fight against separate but equal. Law schools in Texas at the time did not accept black students. In 1946, this fella Sweat applied to UT, the law school. He was denied because he's black, and he was sued on equal protection grounds. The trial judge said the state can come up with a fix. I'll give you 6 months to come up with a fix. I'm not saying you have to accept them. That's an option you can do. You can integrate UT, but you have 6 months to deal with the issue. So what they did in that time is they established a temporary all-black law school, and they planned to open a permanent one. So no longer were Texas law students required to go out of state. Black Texas students who were interested in the law, they didn't have to go out of state. They could go to this temporary all-black one, and eventually what would have been the permanent all-black law school. So the trial judge dismissed Sweat's claims because he said, hey, well, this is moot now. There are separate but now equal law schools in Texas. Sweat appealed that dismissal because he claimed the new school, the new temporary all-black school, was inferior to the all-white schools. So they're separate, but they're not equal. The Texas Supreme Court claimed the schools were substantially equivalent. So basically, they're the same. They're pretty much the same, so separate and equal. Well, this gets appealed to the federal courts, and there, Sweat argued, first of all, there's no rational basis for assuming Texas's law, like underlying law, the one that separated the races to begin with, that they have different intellectual potentialities and should therefore be educated differently. So what that means is the Texas statute that created separate law schools or separate schools, the idea was, well, blacks have different intellectual potentialities. In other words, they're not as smart, so they should be educated in different schools. Sweat's arguing there's no rational basis for that claim. That's just sort of a wild claim, and they're not suggesting they need to show that there is a rational basis there. In regards to the separate but equal issue, Plessy, the Sweat side is saying Plessy doesn't apply because they're decidedly not equal. The state pulled this school out of their ass in 6 months. The facilities are not the same. The budget's not the same. The library is not the same. The faculty is not the same. The reputation's not the same. And when it comes to law school, one of the, we see these rankings for law schools all the time. Well, included in those rankings are budget, library resources, faculty, reputation. So on its face, Sweat is saying these are not equal. These are not equal institutions, so this violates separate but equal. Sweat also says if the court decides that Plessy is applicable, they should overrule it. It's unconstitutional. Painter, who is at the time the UT president, says Plessy and other decisions create separate but equal, and that's fine, provided that they're equal. The history of the 14th Amendment, Painter claims, does not say anything about the intention to integrate schools. The 14th Amendment does not require, and there's no historical record that indicates that it should require a state to integrate or to prevent them from creating separate but equal facilities. Painter disagrees with Sweat's claim that the two facilities are equal. They're saying no, they're fine. They're pretty much equivalent. They're substantially equivalent, as the Texas court said. Right? Basically, what Painter and the Texas court mean by they're equal is you can get a law degree from both of them. So the question here is, does this separate but equal admissions policy, so having an all-black school and an all-white school in Texas, does that violate the Equal Protection Clause? And the court holds unanimously that it does. It violates the 14th Amendment, and they rule in favor of Sweat. And the reason for this, is because they say there's no world in which that interim all-black school, or even the permanent one, could be considered substantially equal to the main UT law school. UT's got a good law school, even in the 50s. And to say that they're substantially equal, that you could gain the same education and the same opportunities from an interim all-black school is ludicrous, says the court. All of those things that Sweat sort of pointed out, the faculty, the reputation, prestige, student body, library resources, all of that are substantially worse at the all-black school. They're just not as good as the UT school. So based on Gaines, that one that I just briefly talked about from Missouri, and other precedents, ones that we haven't talked about, Sweat has a right to a legal education that is substantially equal to whites. So it's not, yeah, he has a right to get a law degree. It's that he has the right to get a law degree that is equal to one that a white person would have an opportunity to gain. So Texas had to admit Sweat to the main UT law school. The consequences here are that it really reestablished, I have here established, but it really reestablished that equal matters when we're talking about separate but equal. It's not just separate, they have to be equal. And in this case, the facilities were not equal. Sweat did not, however, address Plessy. So even though Sweat was required, the court required Texas to admit Sweat, that didn't say anything about Plessy. So separate but equal still lives here. After 1950, the court says it can live provided that equal is meaningful, and equal has sort of this substantial and substantive meaning. They ignored Plessy here, and there's a couple reasons they may have done this. The first is they didn't want to avoid controversy. This is the 1950s, well, the 1940s and the 1950s, and you know, the country is still deeply divided on the question of segregation here. But I think the actual thing that went on, the reason that they sidestepped Plessy in Sweat, is that they knew that it was over. They knew Plessy was not going to live much longer. They knew, not the guy, the precedent. They knew that it was going to be overturned very soon. And they wanted that perfect case to overturn it. They wanted the perfect case that maybe wouldn't anger people so much, or, well, it did, but maybe sort of the perfect legal nail in the coffin. And they got it a couple of years later in Brown versus the Board of Education of Topeka. You'll see here I have Brown versus Board of Education 1. That's because there's a second one. You'll see what I mean in just a little bit. So Kansas had a law that allowed cities with populations of 15,000 or more to segregate their public schools. Smaller cities couldn't, just as a sort of a feasibility issue. Linda Brown was an 8-year-old black girl. She lived in an all-white neighborhood and lived very near a whites-only elementary school. She had to go past the all-whites elementary school to go to the all-black school. Her father sued the district on equal protections grounds, saying this is unconstitutional. So what actually happened here is there's a bunch of different cases from around the country. Brown is just like the one. They consolidated these 5 cases that were challenging public school segregation. They first heard oral arguments about this case in December 1952. They heard them again later on in December 1953. So that allowed newly appointed Chief Justice Earl Warren to participate in the case. And that history shows that ended up having a pretty significant effect here. The background of Brown is really interesting. The people in the community that went to school with Linda Brown, they really liked their all-black school. It was actually a pretty good school. It was probably even equivalent to the neighborhood the whites-only school. Some of the kids and their families didn't want to actually go to the integrated schools. They liked the segregated school, but that's not really what this is about. So it was sort of a bigger picture issue. But I suggest you go read about some of the background of Brown. Linda Brown's still alive. She just turned 75 last year. She's not that old. Think about that. So Brown's argument here is that distinctions based on race and color are arbitrary, and they absolutely violate the 14th Amendment. The evolution of racial discrimination jurisprudence, by which they mean things like Gaines and Sweat, render Plessy no longer applicable. We've chipped away at separate but equal over time, and therefore Plessy needs to go. They remark that social science evidence, so psychology and things like that, establish that official segregation is psychologically damaging. It doesn't matter if the facilities are equal, and in fact, it doesn't matter if the black facilities are better than the white facilities. There is a psychologically damaging effect to perceiving oneself as inferior, which is what segregation may do. That's exactly what they claim. It instills a sense of inferiority. The Board of Education says the schools are equal. Plessy is good law and should control here. So they're separate, but they are equal. So Sweat said there's a meaningful component to equal. Well, these are equal. And they say, okay, maybe there's this argument that there's some damaging effect of segregation, but there's no finding that the kids in this case, so kids like Linda Brown, have suffered any damages from attending segregated schools. What they're trying to say is that the court doesn't take hypothetical cases. If there's damage, they can hear that case, but there's no damage to show here. The other side of that is something I say a lot. The court usually doesn't care about the individual involved in the case. They care about sort of the broader legal and political and social argument. So, the legal question here, can Kansas segregate the schools? And the holding is no. That violates equal protection, and they rule 9-0 in favor of Brown. The reason I said Earl Warren being on the court was important is because it's widely believed that he refused to accept anything that was not a unanimous decision here. So he sort of wrangled unanimity among the justices, even though there were a couple who wanted to dissent. So I think that 9-0 unanimous decision is particularly important in a case like this. And that's why it's important that Warren was there and important that they reschedule arguments to 53. The reasoning here is that, look, in Sweat we said the physical conditions were unequal and therefore this violated equal. Here in Brown, the physical conditions are pretty good. They're both equal, right? The black school has, equal books, equal teachers, all that type of thing. So it is pretty equivalent to the white school. So we're not making the same argument here in Brown that's being made in Sweat. Something else is going on. So they're saying we're not going to decide based on tangible inequality. Instead, we have to look at what they say. They have to look to the effect of segregation itself on public education. They say we can't go back to 1868 when the 14th Amendment was ratified. We can't go back to 1896 when Plessy was decided. We have to look at the state of public education now, in 1954. Here, in 1954, education is one of the most important things the government does. The majority writes, it is the very foundation of good citizenship. Where else are you going to learn where else are you going to learn civics? So in light of that, in light of being this very crucial, important government thing, it has to be available to everyone equally. Now again, we're not talking about tangible inequality here. So what do they mean by equal? They say, even though the tangible factors are equal, the intangible ones are not. So even though the books are the same and the teachers are the same, the ability to gain an education is different in those two schools because of intangible factors, like the mere fact of being segregated. Separation of blacks generates what the court calls a feeling of inferiority. They agree with Brown from that from the Brown attorney side, and they say especially when separation is state endorsed. So, okay, you're getting a good education because the teachers are good and the books are good at your all-black school, but you still live in a state of affairs where the state is saying, we need to keep you separated from your peers. And that generates a feeling of inferiority, and that leads to tangible differences in availability of education. Right? So this effect, which is not great when it comes to adults in law school, is particularly insidious, or what they call pernicious, when we're talking about kids. Linda Brown was 8 when this case first was heard. They say, in the field of public education, the doctrine of separate but equal has no place. And the argument here is that even if everything is tangibly equal, it can never be equal because these kids don't have sort of the sort of wherewithal to understand that they are potentially gaining a great education when they don't know what the other side looks like, right? Maybe the grass is always sort of greener, but that has an insidious effect on children. So, segregation in public education is a 14th Amendment equal protection violation. So the consequences of Brown, well, it didn't really overturn Plessy. Not officially. If you go on Wikipedia, it'll still tell you it overturned Plessy, but not really. But it kills separate but equal. It strikes at the heart of Plessy. Importantly, what we got from that Sweat case was that equal matters. What we get from Brown is that equal is not just tangible equality. So in those cases like Sweat, the court was considering things that one could quantify and sometimes qualify. Prestige, library resources, so on and so forth. Here, they're considering the intangible impact of discrimination. What does it do to a kid's psyche? In fact, this opinion was criticized greatly for citing sociological and psychological work. Some people thought that had no place in a legal argument. In fact, people to this day believe that has no place in a legal argument. Just last term, Chief Justice Roberts referred to something as sociological gobbledygook. So it is controversial, especially in 1954, for the court to be sort of using something a little bit outside of the law to influence their understanding of the law. Well, you can't do this writing quiz because we're not together. But let's move on to Brown versus Board of Education 2. We'll talk about this case, and that's where we'll end for the day. So this one is the year after. So in that original case, the one we just finished talking about, the court didn't deal with how to fix the issue. So in the Sweat case, they said, yeah, this is a violation of separate but equal because it's not equal. UT, you've got to let in Sweat. They didn't do that in the first Brown versus Board of Education. They didn't say, yeah, Linda Brown gets to go to the all-white school now, because that would have had much more massive consequences just by the very nature of there's more kids going to school than there are law students. So they scheduled separate arguments for the following term so they could figure out, hey, how are we going to do this? How are we going to enforce the original Brown? Some groups, like the NAACP, argued that desegregation had to be now. It had to be absolutely immediate. Others, particularly the southern United States, said it has to be gradual. It's going to be way too burdensome to do it right now. We're not going to be able to figure everything out. So it's got to be gradual. So Brown's argument, and really at this point we're not even talking about Linda Brown anymore or her father, really. We're talking about the groups who think this should be happening or shouldn't. The Brown side says within geographic district, within the limits of geographic districting, black children should go to their school of choice right away. So they're like, okay, we're still going to respect that there's geographic boundaries, there's school districts, but within that, black children should pick whatever school they want. Only an order from the court for that immediate integration can vindicate the constitutional rights that have been violated. So in the original Brown, the court said, well, rights are being violated by segregating schools. What Brown is arguing here in the second Brown is that if we allow a gradual change, people's rights are still going to be being violated. And it's just like, what, we're going to live on the promise that eventually they won't be violated anymore? No, the only way to get around that issue of violation is to immediately allow those rights to stop being violated. And sort of practically speaking, there's no evidence that the gradual desegregation is going to be any better. They say if the court allows that gradual adjustment, they should, instead of making a decision as a whole, they should send cases back down to the district courts with very specific directions on how the process should begin. And they need to set an outer time limit. So they need to say something like, you got to be done by 1957. You got to be desegregated by 1957, or whatever the time might be. And they say this is the only way to stop gradual from becoming never-ending. They're worried that particularly the southern states are going to be like, hey, yeah, we're working on it. We'll get there. We'll get there. When then all of a sudden it's 1996 and they're like, hey, we're still working on it. That's what they're afraid of here. The Board of Education argues this has to be gradual because different school districts have different conditions, they have different availabilities, all this. So the speed has to be determined by those school districts. So to demand that everybody follow a uniform standard right now is going to be problematic. Immediate desegregation would be too hasty. It would be problematic. And it would interrupt the educational process. So in trying to make sure that everyone has equal access to education, it would be halting the quality of everybody's education. They agree that trial courts should handle this process, but they think it should be gradual. So what does the Supreme Court think? They say who should be responsible and what's the time frame? Again, in a 9-0 decision, they say desegregation has to happen with what they call all deliberate speed. Well, again, the court is remarkable, stunning in its clarity about what they mean. It's not clear what all deliberate speed means, but they do say implementations are going to be local decisions. We're not going to make a decision here for what should be happening in a local school district. The reasoning for this is that only the local boards know the local conditions, so we can't make these decisions. So the implementation has to be guided by the principles of equity. Right? We're going to balance public and private needs. So the principle of equity is the guiding force here. This is the guiding motivation. Well, people see principles of equity as sort of different. They say school districts have to start. You have to prompt and reasonable start. You can't have forever to decide how you're going to do it. You need to start doing it now. Even if it can be gradual, you need to start it now. And then what's going to happen is the courts are going to decide, the trial courts are going to decide if those districts are actually complying. So, hey, okay, start right away, figure it out as you go, but you don't have to do it overnight. And we're going to keep checking in to determine if given the local lay of the land and the local conditions, if you're moving quickly enough, if you're moving with all deliberate speed. So basically, the court is trying to say, you've got to start now. We're not going to make you do it overnight, but you cannot delay it. So it can be gradual, but we're going to check and see if you're delaying it for delay's sake. So this is really a huge compromise here. They said, try your best to hurry up, which is not really much guidance at all. I think sort of the common or the conventional wisdom here is that this was a compromise, again, made to reach unanimity. They really wanted this to be a 9-0 decision, so they kind of had to come to this middle ground. But here's the issue. This allowed some states to sort of come up with this term, this phrase, as long as we can legislate, we can segregate. By kicking the implementation of Brown 1 back down to the localities, they could delay it, they could avoid it via legislation, and as we know from history, that's precisely what happened in a lot of places. Brown v. the Board of Education did not get rid of segregation. Segregation persisted for decades. We will talk about cases here that were not that long ago. Nevertheless, the court was pretty consistent with its desegregation rulings. It consistently ruled you've got to desegregate. It consistently ruled that kind of fishy, suspicious separations were probably segregation. But the power given to district judges who, remember, oftentimes are coming from that area. So if you're a district judge in, for instance, Mississippi, you might be from the South. That led to some inconsistent schemes across the country. Led to challenges from both sides. So one side saying they're not going fast enough, and the other side saying we're going as fast as we can, and you're violating our state's rights. So there was a lot of challenges to both sides. So where we pick up when we meet on Monday, we will look at a case from 1971 that looks at whether segregation is being dealt with fast enough and sort of how the trial courts should be handling segregation, even into the 70s. Notice, that's 16 years after the second Brown v. Board. So a lot of times we think of Brown v. Board as this huge change, this huge marker, but it really wasn't. There's still some questions going on as late as the 70s and even well beyond. So thanks for watching. You have a quiz on Blackboard, so once you've watched this, go do that quiz, and I'll see you next week.